The next case is Mahir Silmi versus Deena Assad. We just have the appellant to argue today. The appellee has waived oral arguments. You'll receive 15 minutes to present your argument. The argument is being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or by terms like the child. We've read the briefs and are prepared to proceed when you are, or we've read the brief.
Thank you, Your Honor. May it please the court, Kelly Torn, counsel for the appellant, Ms. Assad in this case. Your Honors, this appeal pertains from a domestic relations divorce proceeding out of Lorain County. It was a short-term marriage where there was one child born out of the marriage and subject to the trial court's allocation of parental rights. The issues on appeal are limited. Thankfully, it's not a full appeal of a division of property and all other issues. It pertains solely to the trial court's adoption of an untimely shared parenting plan provided by the appellee, who is acting pro se in the appeal, that was adopted by the trial court. The second issue that is before the court today on appeal is the valuation of the appellee's asset business, which was disclosed at trial, and testimony and evidence was presented, but not valued by the trial court in its allocation of that property. Your Honors, the issue as to the allocation of parental rights in that shared parenting plan are one of fundamental due process, fairness, and a presentation of claims at the trial court. The record reveals that under the statute, neither the appellee nor the appellant had requested shared parenting in the pleadings. Neither party had filed a proposed shared parenting plan prior to the commencement of trial. Neither party had presented any type of plan during trial requesting shared parenting of the minor child under section 310904. What occurred at the trial is that the parties presented testimony and evidence regarding best interest factors and parenting the appellant's residency in Texas and relocation to Texas, and the appellee's continued residency in Ohio during the marriage, and then the trial court permitted parties to submit shared parenting plans subsequent to the close of evidence. It goes to a fairness issue that the appellee, who not in the complaint, not in any temporary orders, and not in any motion to adopt a shared parenting plan, was not just awarded shared parenting and a residency schedule, but was designated as the residential parent under his own plan. The critical issue, Your Honor, is that, or Your Honors, my apologies, is that the shared parenting plan that was adopted by the trial court was never addressed at trial. It was never considered at trial, and the appellant was not afforded an opportunity to rebut such a plan when she was either on direct examination or cross-examining the appellee at trial.
Counsel, it looks like though that the trial judge did say that that wife appellant was aware of the fact that a shared parenting plan had been submitted to the court, so could have filed an objection.
I agree, Your Honor. The record does reveal that parties submitted them. So the record is a little muddy on it only because the parties submitted them directly to the court via email, but were not filed for several months thereafter. The issues on the submission of the shared parenting plan is that parties were permitted to submit them as a proposal, but it was never set for a hearing. So under the trial court's local rules, generally any type of motion or request for relief gets set for a hearing pursuant to, I believe, Local Rule 3. I wasn't addressed in the brief, Your Honors, as to that issue, but I agree. It was submitted.
So your argument for the local rules is not in the brief?
Correct.
I was going to say, I don't remember that, but that's okay. I don't have a good memory sometimes.
No, that issue wasn't addressed in the briefs, Your Honor. Normally something like that probably would have been raised in a reply brief, but because the appellee didn't file anything, no counter argument needed to be addressed. But when the parties submitted a proposed shared parenting plan, that should have been set for a hearing under, I believe, under 310904, as well as the court's local rules. So what happened was at the trial court, the appellee requested parenting time, and there were arguments made as to what that parenting time would be. The trial court made findings and conclusions that somehow that equated to properly raising a claim for shared parenting. Had it even been raised in the complaint, Your Honor, I would agree with you, but at no point in time was was that prayer for relief ever properly raised. So when it
From
goes...
the emails that were eventually, the emailed submissions that were eventually filed by the trial court at the party's consent, did the email submissions indicate that they had any type of service to the other side?
I'm sorry, do you mean service on counsels?
Yes.
I believe so, yes, Your Honor. I don't know if the emails specifically stated the counsel was copied, but they were circulated with
That's what
trial.
I'm saying. So
Yes.
before the court ruled on the matter, the emails were circulated.
Yes, Your Honor.
So both sides had information regarding,
Correct.
and no objection was filed.
Correct. So the motion for new trial was the objection on the adoption for the shared parenting plan. If the court reviews the record and the consolidated appeal for the new trial motion, the trial court issued a judgment entry that referenced those emails, saying that counsels had consented to the filing of the proposals because they were never filed in the initial submission.
During the trial, did either parent argue for shared parenting?
Your Honor, I don't believe so. I believe father requested parenting, but there was never a formal request for shared parenting.
Or any adoption of any plan?
Correct. So they had discussed possible plans, but there was never a request for such a plan as this, where the child remained in Ohio, remained for exchanges between Texas and Ohio on those lines. The appellant had requested that she be designated the residential parent and legal custodian of the minor child because she had always been the primary caretaker. And Your Honors, in looking at that under 310904, the purpose of the statute's 30-day timeline is so that a party is able to prepare and present evidence and claims as to that proposed plan. So when the trial court adopted the shared parenting plan, and then again when it denied the motion for a trial, it cited cases such as Gould, saying that the 30 days is not mandatory but instructive, it's permissive, a trial court can always accept an untimely plan. The appellant concedes that that's case law in Ohio and that's valid authority, but those cases all cited by the trial court pertain to cases where the plan was filed untimely prior to trial. So
Were the parties represented by counsel? I can't remember.
They were, Your Honor.
And below.
Correct. Both parties were presented by counsel. The appellee's counsel withdrew during the appellate process. But both counsel engaged in the new trial hearing as well on remand from this case.
I'm just trying to figure out why counsel would just sit back and not object and say, Judge, you can't consider this.
That's a valid question, Your Honor. It was separate trial counsel. I'm not sure why an objection wasn't raised, but I think it goes to the idea that normally a hearing would have been held because the details of the plan that was submitted were never presented at trial. In fact, the evidence that was submitted at trial was actually contrary to supporting any type of shared parenting plan. And I would direct the court to page 9 of the appellant's brief, where the transcript was cited on September 1st, 2023, pages 177 through 178. The parties made no attempts to communicate with each other during the pendency of the case between April 22 and May of 23, when the child was residing with the appellant in Texas. And then the testimony further demonstrated, and as referenced in the trial court's judgment entry of divorce, the appellant would not communicate with the appellee in any form and said she actually went to her father. So this was a case where the parties had no effective means of communication. They didn't attempt really communication, especially because there was no court order for a program such as Our Family Wizard or any other type of communication process. They didn't talk. And the issues on that shared parenting plan is that under 310904, when you're looking at the factors that justify shared parenting, the parent's ability to communicate, cooperate, are essential to any type of shared parenting plan, whether the child reside with mom or dad or this state or that. In this case, this court specifically has affirmed on numerous occasions, including a case Spiker v. Spiker, that if the parties are unable to communicate, a trial court not only is justified in not ordering shared parenting, but in terminating a previously agreed to shared parenting plan. That's an essential element, is that parents are able to discuss, communicate about the child, and reach agreements about the child that was absent in the evidence here. And that goes to the second portion of the assignment of error on the shared parenting plan. I'm sorry, Your Honor, you look like you keep going to ask a question. I don't mean to interrupt you. My apologies. The issues on the evidence presented is that under the statute, the trial court didn't consider any of those elements, didn't consider any of the statutory factors, didn't cite the statute, and didn't actually address whether or not shared parenting was in the best interest of the children. So when the court looks at the trial court's judgment entry of divorce that actually adopts the appellee's proposed shared parenting plan, the only finding on page 8 ordering it into effect is that, consistent with the shared parenting plan, the following information is reiterated in this judgment entry and as detailed in the attached plan. The court made a finding that somehow shared parenting was in the best interests, but never actually addressed any of the testimony or evidence in the record. So under an abuse of discretion standard, Your Honors, that is an abuse. If the court can't even point to any competent, credible evidence in the record to justify its decision, then how are you as the appellate court supposed to find that it either is an abuse or not? Instead, the trial court simply said, well, appellee proposed this plan, we're not going to hold a hearing on it. The appellant couldn't have known what the details of the plan that's being submitted were, but I'm going to adopt it anyway just because there were some issues with parenting on the temporary orders. It's a due process. Had the appellant been presented that plan beforehand, she could have identified the issues with it, the issues with the exchanges on a 2-month cycle of a minor child between Texas and Ohio, that it's not in the child's best interest, and that these issues needed to be addressed. As to the issues of division of property, Your Honors, it's one singular asset. It's a business that was disclosed in discovery, was identified by the appellee at trial, testified to, but was not valued. So what the trial court did, especially on the motion for new trial, was said, well, there's de minimis value. It's an LLC that held a rental property that was in foreclosure at the time of trial. No evidence as to what the sheriff's sale was. No evidence as to what the value of the property was when foreclosed. No evidence as to the value of the mortgage or taxes or liens that were foreclosed upon. Instead, the trial court said, well, it's a lost asset, so it doesn't matter. I don't even need to consider it. When the possibility is, as the court is aware on a foreclosure, if it gets sold at sheriff's auction and there's a profit, above and beyond any lien that's being foreclosed upon, gets divided or goes to the LLC and then divided to its members. The trial court should have valued the appellee's percentage ownership of the LLC. And then if it wanted to allocate it to him, okay, but then somehow contributed or at least allocated the value of that business in the division of property. Instead, it just said that the appellee shall retain the business, shall indemnify and defend the appellant on all liabilities and encumbrances thereon, and we're done with it.
Well, it sounds like the court valued the property, but said it didn't have anything other than de minimis value and didn't have any impact on the division of property. Now, there may not be evidence to support that, but it sounds, the reason why I'm getting at that, because there's an issue whether if the court didn't value an item, marital property, is that a final appealable order or error? So in this case, it sounds like you're arguing that there was a valuation, it just was incompetent. It was not a competent valuation because there's no evidence to support that.
I believe that's clarified in the new trial ruling, Your Honor. I believe in the judgment entry, it just said he has a business and it's allocated to him. There was never a finding as to value. On the motion for new trial. Sorry, go ahead.
Then it might not be a final appealable order.
If the court sees it that way, that is a possibility, I agree. I think under the new trial order, that is when, upon raising the objection to that issue, the trial court found that it had a value of 0 and said because it was de minimis, it did not need to be valued in the judgment entry of divorce in denying the motion for new trial. I believe that was clarified in the subsequent entry, but I agree with the court that it wasn't properly valued in the judgment entry of divorce.
Would not being properly valued in the entry be a reason for a new trial if there was some testimony about value?
I'm sorry, can you ask your question?
Could it just be a problem with the judgment entry, the judge adding things to the entry, or would it justify a new trial?
I believe it would have justified a new trial, Your Honor, because it's not only an irregularity, but it's contrary to law under Civil Rule 59. That was part of the reason why it was included in the motion for new trial.
On appeal, though, did you make an argument about that in the new trial assignment of error?
Yes,
or
sir.
was it just about the custody issue?
The appellant's brief, I can actually point you to the page if I can get there quickly. I know our briefs are long and we attach all the orders, so give me one moment. It was page, I believe, 14. Your Honor, it was brief in the appellant's brief, I agree, but there was a citation to the fact that the division of property issue on new trial was rejected by the trial court and was in error under Civil Rule 59 on an abuse of discretion standard. The issues on that new trial issue specifically, Your Honors, is that all three issues are an abuse of discretion. It's not a case where the trial court is being reviewed under a de novo standard of review. It's just whether or not the trial court lost its way or acted or issued an order contrary to law such that the court reverses its decision. Under this specific set of facts, Your Honors, we would contend that by adopting a shared parenting plan that the appellant was never provided prior to trial, failing to value and allocate the entity, the appellee's entity, and then denying the motion for new trial do constitute an abuse of discretion. We would request that the judgment entry, both of divorce and denying the motion for new trial, be reversed and remanded for further proceedings, and that the court sustain the assignments of error. And if there's no other questions, I appreciate it. No, my just that time.
Thank you.
Thank you, Your Honors.
The court will take this matter under advisement and issue a ruling in due course. Clerk of Courts will mail you a copy of the decision on the day it's released. Also, our decisions are posted on the Ohio Supreme Court website. The court is going to take a recess until noon. Thank you.
Thank you, Your Honors.